Hi everyone, I'm Amy Henderson, Environmental Scientist in Region 1. I wanted to let you know that the department is continuing to partner with Sustainable Conservation to accelerate the pace of habitat restoration throughout the state of California by giving restoration projects an alternate permitting path through the Habitat Restoration and Enhancement, or HRE Act program. We prepared this informational training video on the HRE Act program to help you better understand how it works and how to use it to advance restoration. Now I'd like to hand things off to Sustainable Conservation to talk about the details.
Hello, I'm Katie Haldeman with Sustainable Conservation. Sustainable Conservation sponsored the HRE Act, and we're collaborating closely with DFW headquarters and the regions on program implementation. This informational video will help you explain the program to applicants you might be funding or collaborating with, or who have projects you might be reviewing, and we will help you utilize this important tool to advance the department's restoration goals. During this informational video, I will first explain the legislative intent of the HRE Act, its key elements, to familiarize you with the application and approval process. Then Amy will talk more about the coordination with DFW headquarters that's involved with HRE Act approval, and then towards the end of the video, I will also share information on where to go for more resources. Let's talk about development of the HRE Act, which Sustainable Conservation sponsored and created in collaboration with DFW to give small-scale restoration projects an alternative, expedited permitting pathway from that of development projects. Based on feedback from surveys of restoration proponents across the state, we all set out to create an alternative, front-loaded application process for DFW's two key approvals: the Section 1602 Lake and Streambed Alteration, or LSA, agreements, and Section 2081 California Endangered Species Act, or CESA, Incidental Take Permit. Legislation was developed to shift the traditional permitting process for restoration, putting environmentally beneficial projects on a separate track from development projects, allowing for an expedited review. This can encourage more restoration and help to achieve the department's mission to protect and restore habitat and recover species. Now that I've explained the legislative intent, I would like to give you a basic description of the process created by the HRE Act. As I mentioned earlier, the HRE Act creates an alternative process to the issuance of both a 1602 LSA and CESA 2081 Incidental Take Permit for any qualified restoration project that would otherwise need approval by the department. The Act specifically mentions that approval under HRE is in lieu of any other permit, license, agreement, or other approval issued by the department. Another key feature of the HRE Act is that it's linked to an existing permit for restoration: the State Water Board's 401 General Order for Small Habitat Restoration Projects, or what we like to call the SHRP. The idea behind this linkage is to coordinate the two permitting processes, which have similar information requirements, and in some cases use the Water Board's SHRP process as a baseline for review of HRE Act projects. Now I'll talk a little bit more about this process as we move through the video. State permitting for small-scale habitat restoration projects is now more coordinated. If a project qualifies for the California Environmental Quality Act, or CEQA, Habitat Restoration Categorical Exemption 15333, though the project can utilize a different CADEX such as 15304 or be part of a programmatic MND, it may qualify for the SHRP from the Water Board, which in turn means the project is qualified for the HRE program. Now, let's talk more about the different project types covered under the HRE Act, as well as the application process. The HRE Act covers restoration project types focused on aquatic habitats, such as creeks, rivers, lakes, and streams, and other water bodies. So these are habitats that DFW staff protect through the 1602 program, and that also require Water Board Section 401 permitting. You now have the option to review projects proposed in these habitats under the HRE Act. There's a variety of project types that can be covered. Some examples include biotechnical stream bank stabilization, invasive species removal, native plant revegetation, culvert upgrades, fish passage projects, and more. Let me show you a couple examples of projects that have used the HRE Act process. Here's a project in Sonoma County, which received Proposition 1 funding from the California State Coastal Conservancy and used the HRE Act's Section 1653, or 30-day process. The overall project will upgrade 3 stream crossings and hydrologically disconnect over 2 miles of roads that are currently draining and contributing significant sediment loads into tributaries of Sonoma Creek, a steelhead-bearing stream. Here's a project in Santa Barbara County, which received Fisheries Restoration Grant Program, or FRGP funds, and used HRE Act Section 1652, or 60-day process, as an alternative to 1602 permitting. The project involved removing a fish passage barrier, a concrete stream crossing, and installing a new bridge on Kyoto Creek in the San Ynez watershed. Now let's talk about project eligibility. And here's where the Water Board's SHRP comes in. Now, to use the HRE Act process, projects must have either obtained approval under the SHRP or be eligible for approval based on the SHRP's current conditions. For example, a project may already be covered under a Water Board programmatic permit, such as the case with the FRGP projects, but as long as the project is eligible for the SHRP, it also qualifies for HRE approval. In addition, all projects must be voluntary restoration, not require mitigation or under court order. The project must also have the primary purpose of improving fish and wildlife habitat. Projects must also be consistent with the current conditions in the SHRP, which include size limit of 5 acres or less, and the SHRP's current linear foot restrictions on disturbance to a segment of stream. These terms and conditions can change as the Water Board updates its permit. As you can imagine, the projects eligible for using the HRE Act process will represent a subset of your total 1602 and CISA 2081 permitting workloads. One of the key features of the HRE Act is that it's a front-loaded application process that makes applicants provide the necessary information required by the law in their initial submittal, rather than DFW staff having to do extensive back and forth requests for information. This front-loaded application process requires applicants to provide complete applications, but allows for an expedited approval process. While it's not required by the law, we're strongly recommending applicants request a pre-application meeting to get advanced feedback from DFW staff on their project's design and environmental protection measures, so they can prepare a complete application. You can also provide insight about local watershed conditions, specific work windows, and more. That can all be incorporated into the application. There are 2 application processes, each with a different timeline. Under the Section 1653 process, for applicants with their SHRP Notice of Applicability, or NOA, in hand, the Act provides for approval in no more than 30 days. Under the Section 1652 process, for projects eligible for the SHRP, but without having an NOA in hand, the Act requires approval in 60 days or less. Each of the pathways has a different application process, and I'll get into those details next. First, let's talk about the Section 1653 or 30-day process, the simpler of the 2 review pathways. Here, the applicant has their SHRP Notice of Applicability, or NOA, in hand. Then, the applicant submits the NOA to you, along with all the information sent to the Water Board and any additional information on species protection measures that aren't already included in their Water Board application. These additional species protection measures will be the key part of your review. This amounts to a 1-page checklist application form. The Section 1653 or 30-day process is really a coordinated process between the Water Board and DFW. Headquarters has worked closely with State Board staff, so information that you need is required by the Water Board in its SHRP application, and is passed on to you via the Water Board application materials. Now let's talk about the 60-day or Section 1652 process, where the applicant does not have a Water Board Notice of Applicability in hand from the SHRP. Because of this, there are additional information requirements in the Section 1652 application and the Act allows the department 60 days for review, given the additional information needed in the application, as compared to the more streamlined Section 1653 process. The applicant must link their project to existing manuals or guidance documents or prior approved permits. Examples include the California Salmon Stream Habitat Restoration Manual, NIMS Fish Passage Guidelines, and others. This helps demonstrate the legitimacy of the project. Then, as part of your technical application review, you will need to evaluate whether enough information has been submitted to adequately describe the project, as well as how the project will avoid or minimize potentially significant impacts. This application requires environmental protection measures be built into the project description. An exhaustive list of protection measures is not needed. However, the application must demonstrate sufficient measures are in place to avoid and minimize potentially significant impacts. Headquarters staff has done its best to reflect what the Act requires in the Section 1652 application form itself to help you with this review. This brings us to CEQA, which you all are likely familiar with. Under HRE, a project must be eligible for the CEQA categorical exemption 15333 for small habitat restoration projects, per the requirements of the Water Board's SHRP. However, the project may be covered under a programmatic CEQA document as long as the project, as a standalone project, is in line with the CEQA exemption. A most likely instance of this would be getting coverage under a programmatic CEQA document for FRGP or a local watershed restoration program. To describe things a bit further for each approval process, under the Section 1653 or 30-day process, the SHRP demonstrates that the project is eligible for CADX 15333. In addition, this process is considered ministerial under CEQA, meaning DFW approval does not trigger CEQA. For the Section 1652 or 60-day process, as part of the application requirements, project proponents must submit enough information to demonstrate that potentially significant impacts will be avoided or minimized through environmental protection measures. That is a key element of the 15333 exemption, and you'll be reviewing the application for this information. If the project meets these requirements just stated, in our view at Sustainable Conservation, the HRE Act does not require further CEQA review by DFW. The department's current interpretation of the law is that there is discretionary decision-making involved in the case of a Section 1652 or 60-day process. So with that, DFW chooses to file a CEQA Notice of Exemption, or NOE, for some projects under this section. DFW headquarters will provide additional direction if DFW believes a notice is required. Let's talk about monitoring. There is a monitoring element of the Act. However, it's important to know that applicants can submit monitoring plans and reports from other agencies, including those from Water Board permits. In the event a project does not have monitoring required by other agencies that the applicant chooses to provide in the HRE application, there are requirements as part of the Act that largely revolve around implementation monitoring. That is, the applicant do what they said they were going to do to implement the project design with all associated protection measures. There are questions within the 1652 application to ensure applicants provide the information required by the Act. Fees for the HRE Act follow the current 1602 LSA fee schedule, including projects that might involve incidental take under CESA, meaning no additional Section 2081 fees. Now, Amy is going to talk about coordination with DFW headquarters.
Let me give you a general overview of how a request to use the HRE program is processed and the coordination between the regions and headquarters in Sacramento. Please reach out to the HRE Act coordinator in Sacramento with any detailed questions you may have on processing approvals. To be considered for approval under the HRE program, an applicant sends their request form to headquarters. They review it for completeness and then send it to you at the regions to perform a technical review. Under the 1652 or 60-day process, the region recommends headquarters approve or deny the project or consider the application incomplete. For the 1653 or 30-day process, the project is considered either consistent or inconsistent with the HRE Act. Finally, the director signs off on the request with the HRE Act coordinator's help getting it through the process, and notification is made to the applicant. The review process runs through headquarters in part to maintain HRE Act consistency across all the regions, as habitat restoration and species recovery are state priorities. Why use the HRE Act instead of traditional 1602 and/or CISA 2081 processes? There are several reasons why the HRE Act process is beneficial to moving restoration forward. HRE Act creates an incentive for applicants to plan and complete more high-quality restoration projects and help meet the department's habitat goals. The Act creates an opportunity for the department to increase partnerships with landowners and project proponents who want to better steward their land and improve conditions in their areas. Higher quality, complete applications that are part of this upfront process can result in better restoration project design and implementation. Be sure to get in touch with the HRE Act coordinator in Sacramento or Sustainable Conservation if you need more assistance in using the HRE process. Now Katie is going to talk about resources for HRE Act applicants and DFW staff.
Sustainable Conservation has been collaborating with the department on the implementation of the Act since 2015. There are a variety of resources available to assist applicants and staff from the department, including DFW's HRE Act website, which includes application forms, information on project planning, timelines, and other valuable information. Technical resources on our website, www.suscon.org, including a one-page general information fact sheet, which is helpful to pass on to applicants so they know what the Act is and what it does, and a detailed guidance document for preparing HRE applications. Now, this is a living document. We continue to update it as additional questions arise, and we encourage you to let us know if you think updates should be made. We also provide free technical assistance and pre-screening of applications to increase the likelihood of DFW receiving complete applications that can approve, especially for new applicants. As we talk to applicants, we will continue to encourage pre-application meetings with DFW to get feedback on their projects prior to submitting an application. For more information, you can reach us at restoration@suscon.org, or you can call or email the HRE Act coordinator in Sacramento. Thanks for watching.